All right. Well, good afternoon officially, everybody. My name is Chad Engelhardt, and I'm the chair of the Negligence Law section of the State Bar of Michigan. We're very happy to have you join us. Looking at the list of attendees, it strikes me a couple of things. Number one, in some ways, we're going to be preaching to the choir today, but that's not a bad thing. We're reinforcing the good and giving you tools to use in the future. Number two is that we have a really broad range of experience levels of lawyers in different practice areas and judges joining us today. So welcome all. Because we have some folks that aren't always members of the section that have been invited to join us, I want to give you a little bit of information about the negligence law section and what we do. So the negligence law section is one of the largest, busiest, most active sections of the State Bar of Michigan. And importantly, it's composed of members from both sides of the V, both plaintiffs and defendants and mediators. And all the decisions, policies, positions taken by the section have to be done on a consensus basis. Our leadership and membership by bylaw requirement is made up of half plaintiffs' attorneys and half defendant attorneys. And in order to make any decisions requires not just a majority, but a super majority of and a consensus of both sides. There's a lot of intelligent debate, and our primary goal is preserving the civil justice system, increasing legal scholarship, and central to today's talk, promoting civility and professionalism in the practice of law. Before I introduce our fantastic speakers, I want to take a minute and tell you about some upcoming events. And actually, let me start with a quick announcement for those that didn't hear. We had an event that was scheduled for October 26th in Troy. Unfortunately, imagine this, a conflict developed. Another major, and one of our strategic allies was hosting a major CLE event that day. So we're shuffling, we're gonna make other plans. And so that, we're being courteous and considerate to our colleagues. And so our event is not gonna go on the 26th. Our next major event after this will be a webinar on November 28th. Judge David Groner from Wayne County, Judge Anthony Patty from the Eastern District of Michigan, Bob Riley from the mediation section, and Riley and Hurley, a past chair of this section, and the ever fabulous Judy Susskind, the past chair of the section and the president of the American Board of Trial Advocates, will be holding a seminar on holding effective settlement conferences, best practices for the bench and bar. After that will be in February, we're going to have a rock and bowl plaintiffs versus defendants bowl-a-thon at the Majestic Theater in Detroit. So hopefully you can put those on your calendar, keep an eye on our social media pages, and hopefully we can see you at those as well. I mentioned that one of the core missions of the negligence law section is promoting civility and professionalism. And our speakers today embody that. They are people who we see as not just valuing those same values, but practicing them as well. And so we've invited them to come and speak with us. Amy Blackwell and Dale Hebert from the University of Michigan's Office of General Counsel. In looking at speakers and their qualifications and what they can really bring to our membership, one of the things we look for is both a breadth of experience and a depth of experience. And Dale and Amy both bring that in spades. Both have decades of experience in civil litigation, handling complex medical malpractice and other types of claims. And I mean, that's amazing considering that Amy's only 29. So having been practicing for decades, she's like a child prodigy. In addition to both having significant litigation and trial experience, they've both now been at the Office of General Counsel for several years. And in that context, both Dale and Amy have had a broad exposure to hundreds of lawyers in Michigan and across the country, and been able to have some exposure to different practice patterns and different styles and perhaps different personalities. And they've had to cope many times and help their staff and help others in the Office of Risk Management, Clinical Safety, and Office of General Counsel, and help providers at the University of Michigan deal with folks in crisis. And so they're used to managing sometimes tough situations and bringing a level of professionalism and a cool-headedness that lets things prevail. So with that, we've asked them to come and speak with us about some of the things that have occurred at the University of Michigan to promote civility, respectfulness, and professionalism in their context, and how those principles can be applied to your practice. So I'm not taking up their time. Without further ado, I will stop sharing my screen. Oh, one more thing. I have to thank our sponsors. This seminar is being offered at no cost to the general University of Michigan folks, and also to members of the State Bar of Michigan at no charge. And that's thanks to our sponsors, Ringler Financial Structures and Arcadia, also in the structure business. Thank you very much for sponsoring this seminar and for allowing us to offer this at no charge to our members or others. And with that, Dale, I'm going to turn off my screen so you can start sharing your presentation. And Amy and Dale, please take it away. Thank you for joining us.
Okay, bear with me because all kinds of odd things just happened to my computer. All right, can you see my screen, Chad?
We can, Dale. If you just press on the PowerPoint logo in the very bottom, the P, it'll pop up on your screen. And yep, right.
I promise you all, we practiced this 10 minutes ago.
You know, you may have PowerPoint open. You have another screen where the PowerPoint might be open.
See it now?
There you go.
There we go.
Okay, I've got to change the view, right? Okay.
So hit from beginning. Yep.
I got to change this. Okay.
Okay.
There we go.
Hallelujah. Well, thanks, Chad, for the introduction. And hi, everyone. I wish I could see you. I can't. So this is a first for me, and I'll see how it goes. As Chad mentioned, I'm Dale Hebert with the Office of General Counsel at the University of Michigan, as is Amy Blackwell. And looking at this very subtle M block on the bottom, you have probably come to appreciate we are from the Office of General Counsel at the U of M. Between the two of us, we are responsible for managing and directing all of the medical malpractice claims and litigation against the University of Michigan Health System. That's kind of significant in part because we are what you call a closed staff. All of the providers, physicians, nurses, MAs, etc., who render care within our facilities are our employees. We don't have an independent medical staff with their own insurance companies and all that good stuff. Just a little bit more by way of background. I have, before joining the University of Michigan, I was in private practice for roughly 35 years. I was primarily a med-mal defense lawyer for most of that time, although early in my career, I had a more diverse practice. I did just about everything: auto, premises, construction, you name it. About 9 years ago, well, and during that 35 years, I had my own firm for about 17 years. And on the bookends of those 17 years, I was a partner in larger firms. For the past 9 years or thereabouts, I have been in-house at the Office of General Counsel. And although now and before I focused primarily on defense medical malpractice cases, I remain exposed to what you guys do on a day-to-day basis in ways that we'll get into as we move along. But I'm no longer in the trenches, but I spent a lot of time in the trenches over the years. What we hope to offer you today is one, we're going to introduce you to how we do things at the University of Michigan, and Amy will largely do that. But two, we want to blend our experiences here at U of M with what we experienced in private practice, because we think it offers sort of a unique perspective. It's given us a chance to sit back at times and look and see, well, what did we do in private practice? What did we see others do? And contrast it with what we're doing now. And we really do believe that this has allowed us to gain some insights we otherwise might have obtained. So I'm going to let Amy introduce herself.
Thank you, Dale, and thanks, Chad, for the intro. I have been in practice 24 years, proudly representing the University of Michigan for the entirety of my career. Unlike Dale, it's always been medical malpractice cases. I was on Dale's team for 7 years as a trial attorney, and then came to the university 17 years ago, primarily working on our pre-suit medical malpractice cases. For those of you who know Dale, I think you'll understand why I would say I am privileged to have learned from the very best in terms of civility with Dale. As I was collecting my thoughts for this discussion, one experience stood out in particular for me. It was the first weeks of being a young attorney, and I had the opportunity to observe a plaintiff's deposition in a malpractice case, of course. And the co-defendant's attorney started. He was attacking, he was obnoxious, he was bordering on unprofessional. And what I found is that yielded very little substantive benefit. The plaintiff was immediately on the defensive and was not at all willing to talk. Then after, an hour of that, it was Dale's turn, and he was kind, but forceful and substantive. And he asked his questions with the utmost civility and respect, and was incredibly effective at getting a lot of concessions. After he was done, the plaintiff's attorney, who happened to be now Court of Appeals Judge Elizabeth Gleischer, leaned over to me and said, "See, you get more bees with honey than vinegar." And that has stuck with me for 24 years about what effective advocacy really looks like. And that was important. Now, also, for those of you who know Dale, to be fair, I've also watched him use his civility to masterfully charm his way out of motions to compel answers to interrogatories and that sort of thing. So there's multiple benefits to being civil. But all kidding aside, I am super grateful to be part of this presentation. I am grateful to all of you who are interested in this topic and for your professionalism. I saw the list of attendees, and I've worked with many of you, and I know how professional you all are. And I think it's fair to say that those who are attending a discussion on professionalism, as Chad said, we're preaching to the choir here, are probably not those most apt in need of that webinar. But thank you for being here, and thanks for having me.
And if there's any questions, by the way, and I apologize for interrupting Amy, if anyone has any comments or questions for Amy or Dale, please put them in the chat or the Q&A, and we'll get to them either at the end or as appropriate throughout the presentation if there's a good stopping point. I apologize, Amy, and
no, that was perfect timing.
And I would underscore, we welcome questions, comments all along the way. You don't have to wait till the end. All right, here's what we hope to accomplish today. And that is to demonstrate that heeding professionalism principles is not only required, but wholly consistent with being a passionate and effective advocate for your clients. And to work toward that goal, we're going to introduce you to, which we really believe and are proud of, our principled approach to addressing malpractice claims, and then illustrate through our approach how the Michigan Supreme Court principles and the bar principles can be effectively integrated into your practice. Few observations first. This presentation as initially complicated or contemplated was much narrower. I had been pestering Chad for a while now to arrange opportunities for me to speak to groups to get the message out about how we handle things. It's kind of frustrating when the first we learn of a claim is a notice of intent or angry letters that filter through our system before they get to us. And I wanted to get them, or we wanted to get the message out. But if you're contemplating a case against the U of M, pick up the phone and give us a call. And you'll learn later what a call like that triggers in terms of our end and looking at a claim. And woven into everything we do is the principled approach we're going to talk about. After being bugged for a while, Chad agreed. But Chad responded saying, well, it's a great idea, Dale, but could you expand it? Could you expand it to maybe draw in other areas of litigation, civil litigation, other than malpractice? Well, since when Chad asks, you say yes. He made me an offer I couldn't refuse. So I went back to Amy and said, here's what Chad would like. What do you think? And we're not holding ourselves out as academics who know all about civility and professionalism and all of that stuff. But we kind of do know how we integrate it into our practice. So we dug into things. And we began by reading the Michigan Supreme Court administrative order from 2020, I believe it was. And independently, we were both struck how closely, inadvertently, if you will, our practice matched many of the principles within that document. And so we enthusiastically said, yeah, we can do this. I mean, this is what we do. So we're going to try and illustrate our practice and juxtaposed with the Supreme Court principles and work in examples along the way. As you will come to learn, we exist, or the environment in which we exist is probably pretty unique. Some lawyers familiar with what we do and what others do would probably label our environment almost an Eden. We operate within a culture that emphasizes doing the right thing in the right way, and we are given the resources to do that. That's the underpinning of how we interact with the plaintiff's bar. It's unlikely you will ever be able to follow our script to the T, but we're hopeful that by illustrating things we have encountered over the years, you can pull away a kernel or two that you can find helpful in trying to implement these very noble ideas into your practices. We also appreciate how challenging it can be to implement professionalism and civility into what you do on a day-to-day basis. But that doesn't mean you shouldn't try. You have to try. And I oftentimes think to myself, we need to remind ourselves this is a profession. It's just not just a way to earn a living. It's a profession. And we are obligated to heed the very rules we read about and know are out there. I get how difficult that was. As I mentioned, I had my own firm for 17 years. I was a busy litigator. And I understand all the pressures you're under and I was under, in addition to the never-ending demands of handling your cases. You're running a business. You got to get clients, you got to keep clients, you've got to make payroll, all that good stuff. And that's a lot of stress. And that kind of stress, I know personally, can bring out the harsher sides of us. But we have to resist that. And we have to be civil. We have to be professional. And as I like to say, do the right thing. We hope that hearing what we have to say will at least cause you to pause every once in a while and think about these principles. Maybe when you're crafting an email to your opposition, or a particularly hostile email, drafting interrogatories or discovery request, responding to a request to adjourn a debt, preparing a motion to compel the day after the responses are due, and so on. Just pause. Every once in a while, just pause and think about these things. Okay. I read and reread this administrative order, and frankly, I love it. I'm not gonna, it's 5 or 6 page document, if I recall correctly. I just want to highlight some of the principles that are behind it. If you haven't read it, please do, and read it closely. It, at least to me, going through this, it kind of reminded why I'm prideful of being an attorney, litigation attorney included. So while reviewing the order to prepare the presentation, we appreciated that honoring these principles kind of helps what we do on a day-to-day basis. Amy will get into more detail on our approach, but civility and professionalism are key components. And I'm going to do a bit of a shout out to Chad and his partners here, because they have successfully worked with us over the years. And by successful, I mean very successful from their standpoint. They're sort of the poster children for being extremely skilled, professional, civil, and just working in the best interests of their clients. That doesn't always mean that we end up with a settlement. We'll get into all the details later, what we do, but we have a nice open exchange with them. They articulate their clients' concerns. They articulate where they think the care may have been substandard. They exchange information throughout the process, and it leads to one of two things, ordinarily, a settlement or them appreciating this is not something they should pursue. Occasionally, and Chad will attest to this, we agree to disagree, but it's an honest disagreement. And occasionally, not very often, we find ourselves in trial. We are not in any way, shape, or form suggesting that you be less than a passionate advocate. These principles do not demand that of you. They demand actually just the opposite. But we firmly believe, absolutely believe, that embracing these principles will make you a better lawyer, make you a more effective lawyer. We witness and experience this on a day-to-day basis. One more bit of context. We work at a nationally renowned academic medical center. And we have lots of mission statements. Tease this out of one of the mission statements. We want to be leaders and innovators in clinical excellence, education, discovery. We want to transform healthcare through superior safety and quality, and our patient outcomes will be the best in the country. I know, being inside this mammoth operation, those are not just words. I can't begin to tell you the infrastructure that exists behind the scenes that moves all this along, that does the research, does the education, advances clinical care, and so on. But I bring this up because this informs what Amy and I do. Our handling of the litigation claims for medical malpractice doesn't exist separate and apart from this mission. It's part of it. And I think you'll get a better flavor for that as we move on. And I'm going to turn the next few slides over to Amy.
Thanks, Dale. So to help provide additional context and background for the rest of our discussion, we wanted to share a little bit about our claims resolution program for our malpractice cases, how the university approaches its malpractice cases. So these are the core principles that guide our response to any medical error or malpractice claim. We commit to compensating quickly and fairly when inappropriate care injures one of our patients. On the other hand, because we all know medical and surgical care cannot be delivered without risk, we commit to vigorously defending in a principled way medically appropriate care, even if a bad outcome or complication occurred. In either case, and this is perhaps the most important principle of all, we vow to learn from that experience, educate our providers, and improve as indicated. Again, as Dale described, our mission is to advance quality patient care. Even if our care was appropriate, we know we may be changed by that case or experience, and maybe there's something to learn from that, even if our care met the then prevailing standards of care. We do not allow the prospect of a claim to prevent us from making improvements where they're warranted. And some places might say, oh, don't make the change for fear of that could be used against us in litigation down the road. That does not hinder any process improvements that we want to make right then and there. These proactive efforts that are all geared toward our patient safety in turn allow us to restore relationships between the patients and providers that they're intending to sue, and yes, avoid unnecessary litigation. So importantly, what's missing from these core principles? First, an assumption that patients or their attorneys are bad money-grubbing people. We have learned from countless interviews with patients and their attorneys that what most often motivates them to pursue a claim is a desire for answers, or that whatever happened to them doesn't happen to someone else. That's borne out by data that we've seen, and that's also borne out by our own experience with thousands of interviews that we've done over the last, at least since I've been a part of it, 17 years, and the many, many years before that. What else is absent from this list of core principles? A win at all costs attitude. If that means dragging people through lengthy and expensive litigation, so be it. We do not take that approach. We know that malpractice cases are expensive and they can be cost prohibitive for plaintiffs' attorneys to take on. We do not exploit that reality by taking a scorched earth approach. What else is absent from this list? We don't pat ourselves on the back or do fist bumps when we win on a technical legal defense or by undercompensating patients injured as a result of substandard care. We do not, when we think that substandard care harmed one of our patients, we don't try and nickel and dime people. We compensate fairly. And yes, we are zealous advocates for what we believe the true damages might be in any given case, but we don't try and cut a deal because we're doing this early, or we don't because we have a technical legal defense. Then we don't try to get a unfair result as a result of that. So in the end, what we're really doing is the right thing for both our patient and our staff. Importantly, this also does not mean settling every case out of expedience or to save costs. Those of you who have worked with us, you'll know that we do step up and compensate when we think it's appropriate, but many times we don't. Either way, we commit to openly sharing information so that the attorney, the plaintiff's attorney, can make an informed decision on whether they think the case is one that ought to be pursued. This also doesn't mean tempering our roles as advocates. We never lose sight of who we are there to represent, which is the university and our staff. We are not patient advocates. Early on in my tenure here, I would hear, oh, tell me about the I'm Sorry program. This is so much more than just kind of an apology. And this is way beyond that. Sure, there are apologies made in the right circumstances, and absolutely, we would never get in the way of that, but it's more than that. And what this does mean, though, if you look at these principles, it does mean we're doing our best to promote advocacy in a civil, principled way. Um, Dale, if you want to go to the next slide, unless you have comments. Okay. So here's, I'd like to get into a little bit about the nuts and bolts of our program in action. An extremely important component to our claims management program is early notification of an untoward outcome. Our providers are encouraged to bring unexpected untoward outcomes to the attention of risk consultants early on. We have risk consultants that are assigned to particular services, and they develop relationships with leadership in that area and those who are in the trenches. We want our providers to know that it's safe and productive to report. They know that something good will come of it if appropriate, that an investigation will be taken and that something good and an important change may be made. So that's been an ongoing effort. We're constantly educating our staff on the importance of that, and then circling back and showing them, improvements that have been made and why their involvement mattered. Yes, we also may learn of potential bad outcomes through our patients or their attorneys. We are admittedly able to take advantage of pre-suit notice provisions that are unique to malpractice claims. It is tremendously helpful, but I will say that the vast majority of time, it isn't the notice of intent that we first learn of a potential bad outcome. We had learned of it from internal sources earlier. Yes, we do get that notice of intent, and they cannot file a lawsuit for 6 months after that's been sent, and we take full advantage of that. But no matter how the claim comes in, we begin a thorough investigation. This will include interviewing the providers involved, offering to meet with the patient and their attorney if they're represented to understand their perspective. If you all are getting electronic medical records today, there's so much information in there, but it's not everything. We know that the patient or their family have a unique perspective, and not everything that they see and experienced is going to make its way to their chart. So that meeting is incredibly valuable so that we're doing a complete and thorough and accurate recreation of events to the best of our ability. And this is important for both of us, that we exchange information equally, and, we will share what our providers were thinking. There's no reason we have to wait for depositions or litigation for that. Importantly, one aspect of orienting anybody at U of M's who's working on claims is reminding everyone we need to keep an open mind and listen. We don't know what we don't know. Every case comes in and we get one perspective from our provider, and we think we got a good handle on it. But you need to keep an open mind. When we have those meetings with patients, we have to be disciplined and really not just go through the motions, and really keep an open mind. Because in the end, we have a shared goal of trying to recreate these events and the consequences of whatever occurred as accurately as possible. And yes, we do get different versions of what happened depending on who you're talking to. But again, so valuable to get that information at the front end of a case rather than during discovery or with depositions. A big component of our process involves teasing out those bad outcomes or complications that occurred as a result of unreasonable care from those that occurred despite the best of care. As you can imagine, all cases that come our way, they start with a bad outcome. And so to do so, we will get expert reviews from, we're fortunate enough to have the best of the best internally, so we can get expert reviews there, or we often will seek expert reviews from outside the university. We want to test our, we don't want to be not objective. So we want to test that with other experts across the country, and we can learn from those other expert reviews from time to time. And again, we do this pre-suit because we want to get as honest and objective a take on the care pre-suit as possible, so that we're not defending care that we really shouldn't be defending. And more importantly, if there's an opportunity to improve, then we're going to act on it quickly and not wait for the legal process to sort its way out. Many times we will take the claim through an incredibly robust committee that we have that is comprised of 30 plus providers, caregivers, hospital leadership, various specialties, and they will review all the events, the information, the expert reviews, and offer thoughts on whether the care was reasonable under the circumstances, whether unreasonable care approximately caused injury, and again, whether there's room for improvement no matter how we see the standard of care type issues. That committee that I mentioned is specifically geared only toward the clinical issues. We do not get into the defensibility of a case. How will the witnesses hold up? How will the documentation hold up? Those things that might affect, we really want to keep it focused on the clinical aspects. And there is, of course, you can't do anything at the university without a committee. So there's, of course, a second committee that would address more the defensibility. Do we settle? Do we resolve? And that's our process essentially from beginning to end. But all throughout, we are engaging with the patient or attorney. We are exchanging information on what our providers are saying. What is your patient saying? What's the family saying? What are our experts saying? Let's share opinions. Do we need to sit down together and have these conversations? This process is entirely voluntary on both sides. And as you can imagine, it just simply does not work absent professional and civil exchanges. And for those of you on this webinar, I know we've worked productively with many of you. And for that, I remain grateful because I can't emphasize enough, it doesn't work unless you're willing as well. If we could go to the next slide, Dale. Thanks. So this is just a high-level view of how a claim flows through our process, and I hope it illustrates the depth of work and exchanges that really occurs before we ever get to a lawsuit. We have the case comes in, then we have this exchange, the analysis, the expert reviews, all that happen, and we have that committee. All that happens before a lawsuit's even filed. In the end, and this is another thing that, of course, when you work at an academic medical center, data is really available and important. And in the end, we know that data, we're doing a recent look back on 10 years of claims from 2013 to 2022. And this data has shown that this principled process works. Of the nearly 1,000 cases that we've handled pre-suit over that 10-year period, lawsuits were filed in only 11%. That doesn't mean that the rest went away. That means the other numbers shake out. We have 30% of those pre-suit claims that came our way from anyway. NOI, patient concern, came from our own providers and we initiated the claim. 30% of those cases were settled, which means it was the right thing to do. We felt like we didn't meet our standards and one of our patients was injured and we needed to do the right thing by them. 59% were closed without payment after an exchange of information with the patient or the attorney. If you remember, one of the motivators for patients and families to sue is a need for answers. So that closure without payment, we spend a fair amount of energy and time on cases that even we're confident fairly early on might not go anywhere. But we know one of our patients was not satisfied. They went to an attorney, they have questions. We want to sit down and, to the best of our ability, offer those answers. They may not always be satisfactory, but at least in that 59% of cases that were closed without payment, maybe there wasn't compensation, but there was at least hopefully an opportunity for the patient or family to receive answers. If we could go to the next slide, Dale. So just to wrap up, some final observations about our process. Again, it is part of and complementary to our QI and patient safety efforts. While one goal or benefit is a reduction in litigation, again, I can't say enough, doesn't mean we pay out of expedience. Many cases we could have resolved for the equivalent of nuisance value that cost us far more to defend in litigation or through trial, but it is so important that we're principled in both directions. And resolving a case never comes at the expense of effective advocacy or our client's best interests. And lastly, we can't emphasize enough the cooperation that must happen on both sides. It just doesn't work unless we have civil, professional, and principled mindsets on both sides. Now, Dale will take us through demonstrating how the principles advanced by our Supreme Court's administrative order on professionalism work within our process, and how we believe these universal principles and concepts can effectively be worked into other areas of practice.
Thanks, Amy. I'll just add what Amy went through in describing our process. We present frequently to audiences. It usually takes us 2 or 3 hours to get through everything in the detail. So that scratches the surface of what goes into what we do. And then I will share Amy's emphasis. We really need the cooperation, good faith cooperation of the patient's attorneys to get this done. In any event, so we teased out some of language within that Supreme Court administrative order. Now I'm going to put them up and offer some comments and examples of what we've seen and participated in over the years. So unprofessional conduct increases the cost of litigation, consumes judicial resources, and I want to emphasize this with little concomitant benefit for the client. Other than for those of you, and occasionally in the past for me, who enjoy the thrill of a deposition or the drama of a trial, and if you're a defense lawyer, the billings that come attached to litigation, trials aren't fun for anybody. Since I've been here in U of M, we've tried, I think, close to 30 trials. And one of my roles throughout is just to support the clinicians involved. And I see the toll it takes on them. I see the toll it takes on them during the 2-3 years that litigation occurs. They have a lawsuit hanging over their head. They have a claim hanging over their head. I have conversations virtually every week with someone who is newly named in a notice of intent. And I have to pull them off the ledge. They see their name in a notice of intent and they see their financial future circumstances unraveling. They see their career unraveling. It's just, and that's particularly with nurses and residents, or we call them house officers. It's painful. And I was once told by a prominent plaintiff's attorney that after a favorable resolution in a case as a plaintiff's attorney, whether it be by settlement or a favorable verdict, at least for the time immediately afterwards, their clients don't feel better. And in a way, their lives darken a little bit because for 2 or 3 years, they were focused on their claim, their litigation. They lived it. And it seems on occasion to delay their opportunity to grieve. And once a resolution occurs, well, now they have time to grieve and it hurts. And money doesn't make that feel any better. So this whole process takes an emotional toll, financial toll. I don't know the inner workings of a plaintiff's firm and what they go through in terms of cost and expenses, other than I know from my end, it's incredibly expensive to defend a malpractice case. Again, a friend of mine once told me a few years back, a plaintiff's attorney, he had put close to $450,000 into a case that ended up being tried, and sadly, there was a no-cause verdict. On my end, the costs are dramatic. I retain very good lawyers. I value what they do, and I believe I pay them pretty well. And I'm happy to do that. What has bothered me more and more over the last few years is the cost of expert witness fees. And I think I'm probably going to get a few amens from the audience on that. But there are cases I have where the expert witness fees are approaching what I'm paying the lawyers. So they're very expensive. You all know that. What else is bad about them? Well, it consumes a lot of time. Again, I can't speak to the world of the plaintiff's attorney other than to observe when they're in trial, they're for 2 or 3 weeks, they're not getting much else done. So that sets them back. I know on my end, the amount of time that gets consumed by our clients, the physicians, the nurses. I am pulling them out of very busy clinical research, administrative responsibilities for them to sit in court for a week, 2 weeks, 3 weeks. And that spills over into their department or divisions, because when they're gone, someone else has to get their, address all of their other responsibilities. So it consumes time and energy on both fronts. And then this is important to me. It delays closure. Being involved in lengthy litigation, whether it ends with compensation or a no cause or a case being dismissed, they need their closure. Both sides need their closure. And why, as a system, would we want to promote delaying that closure at a huge cost across the board? I'm going to draw on my experience, and when I give examples, I want to make a note that I am fudging things a little bit, so to protect the innocent, which hopefully usually is me, and just to help illustrate points. So I want to contrast two real world experiences. Not too many years ago, I had a case involved an 8-year-old boy who had a pretty peculiar issue with his trachea. Had lots of interventions over the years, and he reached a point where he needed a significant intervention, and we were one of the few institutions in the country that would even try it. There was an untoward event, and he woke up from the procedure paralyzed from the neck down. We knew obviously of the complication right away, and that elaborate, robust process Amy just described kicked in, and we began looking into it hard and aggressively early on. Early on, a very well-known, skilled plaintiff's attorney got involved, and throughout, we were interacting. We were doing all that exchange of information that Amy would mention and that we promote. Honesty, we want to hear what you have to say. We want to tell you what we have found out. All that happened. We soon came to the conclusion, yeah, this was not care we're proud of. So let's work toward resolving it. We spent a lot of time gathering information, figuring out what the kids' needs are, what they will be, and how much it's going to cost. I don't go to people to tell me what I want to hear when I'm doing that. That's not my charge from this academic medical center. The charge is they'll figure it out. Make this work for this family, this child. Because apparently the art of negotiating directly is long past, we went through facilitation. And it was the usual. I mean, apart from it was very civil and professional, you start out with a difference of opinion on what it's really going to take a cost to take care of the kid. It was a robust exchange, but a very honest, good faith, professional, and the case resolved for, as you might imagine, high, mid 7 figures. That occurred less than a year after the injury. In addition, throughout that process, we were paying for whatever care the kid needed that wasn't covered by insurance. We made modifications to their home. We provided them with a van to make sure he could get back and forth, because it was the right thing to do. Plus, it would maximize his outcome. So that environment, that exchange we were having with everyone was terrific. It was a horrible, horrible tragedy, but that process was terrific. And to underscore the culture within which I work, not long after the settlement, I ran into the chief medical officer for the entire health system, and I said, "Doctor, I'm happy to tell you that the so-and-so case resolved." You know what the first words out of his mouth were? They weren't, "Well, geez, how much, Dale?" No, they were, "Is he taken care of?" I don't get a pat on the back for trying to quote unquote save money, but I do get a pat on the back for taking care of injured people that deserve compensation. So that was a great example. And for every one example I give you, I could give you dozens of others where it works and now where it doesn't work. This was when I was still in private practice, but it was a ULM case. This was a newborn who had a pretty severe cardiac defect, genetic condition. And not long after delivery or birth, had to undergo surgery to correct the defect. There was an untoward event during the surgery. The child was profoundly brain damaged, CP, wheelchair bound, on a ventilator, tube fed, about as horrible a situation that you can concoct. We did the same thing, dug right into it. We felt we could defend the care, if you want to examine it and look through it through the lens of litigation and experts and all that good stuff that goes into trying a case or defending a case. But we weren't happy with the care. So my charge was to, again, Dale, do the right thing. And this was an attorney that I have dealt with for over 40 years. And he can be incredibly challenging. But we approached early on to engage that exchange of information, and we couldn't get anything out of it. The child's care had been transferred out of our system, so we didn't have access to any of the subsequent records. And we'd asked for information so we could get a handle on the kid's current condition, what his needs are, make all the projections, et cetera, et cetera, et cetera. I was willing, or my client was willing, to resolve the case for a substantial amount of money. Not long after the event, as soon as we finished our investigation. We arranged an initial facilitation, and I got no information during the facilitation, no more information. The only thing I got was a demand that probably would have funded a small country. That just brought things to a halt. We tried a few more times, same thing, no information, no reasonable demand. And then that attorney went dark for 5 years, absolutely dark. And 5 years later, it resurfaces. Same nonsense initially. Took another year to get information from them so I could process and evaluate the case. Long story short, after 6 years, we got the case resolved. And this will never, ever leave my mind. We were at a facilitator's office who, some of you will know, it's Bob Riley's old office. And he has on one side of the room, a conference room with a glass wall. And on the other side of the well, or whatever is in between the conference rooms, was a conference room where I was sitting. And throughout the day, I could look across that well and into the windows of that windowed conference room. The father was there with his daughter, who's in a wheelchair, on a ventilator. She needs suctioning 24-hour day, 7 days a week, every 15 to 30 minutes. The father was in there throughout the day, and I'm watching that. And I'm thinking to myself, if someone had approached this in a principled, professional way, had engaged us like we want people to engage us, he could have gotten the help he needed 5 years earlier. So tell me, which version of events makes the most sense? Which version of events are we best serving our clients? Which version of events are we best serving the system? Which version of events will make you proud to be a litigator, a lawyer? Well, you probably know what side I come down on. And going back to that last case, I wanted to make this observation. Maybe I paid more 6 years later than I paid at the beginning. We'll never know because I wasn't given an opportunity to figure out what I could have settled for early on. What I do know was what I was ready to pay at the very beginning would have taken care of that kid, met all of his needs, and then some for the rest of his life. Did he get a little bit more 6 years later? Don't know. But what I do know, he didn't get anything that would have made his life any better 6 years later than it would have 5 years earlier, or 5 or 6 years earlier. To do the math. Okay. Confer early and in good faith to discuss the possibility of a resolution. These kind of, at least when applied to what we do, all these different principles overlap, and I could probably put our examples up under each, all of our examples under each or all of them. But as you probably gathered from Amy's discussion of our process, this is integral to our process, absolutely integral. And as Amy alluded to, when we are involved in these early discussions, and again, I'm going to applaud Chad and his partners because they help make this all work for us and their clients, more importantly, their clients. So all that's integral to our process. I think Amy touched on this. Transparency, honesty, being forthcoming with each other during that exchange is critical. But again, we're not promoting diminishing your passion and your advocating on behalf of your clients. We're not going to share during those discussions, and I don't expect the other side to share during these discussions any strategical concerns they have. I think Amy touched on this. I'm not going to share, geez, I'm a little bothered about how so-and-so is going to do as a witness when we try the case, or optics with medical records. Frankly, the next case I have with pristine medical records will be the first case I have with pristine medical records. But in any event, we don't share those kind of strategic decisions, but we share what is needed to make an informed decision. Was the care reasonable? Did it harm the patient? And what's it going to take to take care of them? That we share. And the principal or the attorneys that honor all these principles, they share, and we get things done. Doesn't always mean it's going to be a settlement. As Amy cited the statistics. Probably more often than not, it's not going to come with a settlement. But if you're a plaintiff's attorney about to embark on an expensive course of litigation, don't you want to know what you're going to be up against? Don't you want to listen to us? We'll listen to you. And we're able to show you the care is reasonable, and you're not going to start spending money on experts and tie yourself up for 2 to 3 years. Why not? Be principled, professional, honest, forthcoming, and good things will happen. You're going to waste your time, your money, or you're going to get an early resolution that's in the best interest of your client. I'll give you a couple of examples. A blend of my private practice and being here at the U of M that speak to this very concept. This one I was in private practice and involved another. I'm sorry, so many of my examples involve children, but that's my role. a claim was submitted involving the failure to timely diagnose herpes encephalitis. So the herpes virus that works its way into the brain and it's bad. And so the claim was it was not timely diagnosed. The UM did its thing, looked into the care. Another one where they felt that they probably could defend it but didn't want to. So they attempted to engage the plaintiff's attorney. Met with the same thing. Outrageous demands. And just sort of went quiet for periods of time. Then he filed a lawsuit and it made its way into my world. As I'm sure everyone does who gets a case involving injuries, you begin by pouring through the medical records. And I did just that. Back in the good old days when we had paper charts, I didn't have to sit in front of a computer. So I'm leaping through every page and I stumble across some lab result that I'd never seen in all the years I've been doing this. And so I Googled it. And it turned out to establish that the child didn't have herpes encephalitis. She had some obscure, but from across the world virus that there was nothing you could do to change the result. I verified this with all my experts, and then I wasn't really, but theoretically, I was at a crossroads, right? I mean, I could sit on that. I can wait for a Perry Mason moment down the road and use it at an expert step or at the trial even. Worried that if I shared it, the plaintiff's attorney had lots of time to try and craft a workaround to that piece of information. Didn't think there really was a workaround, but in the back of my mind, that would be a possibility. Or I could give him a call and let him know what I found, which is exactly what I did. He received it gracefully and trusted me, but verified, which is what we all should do. And not too long later, dismissed the case. That's the value of exchanges. Now, let's see here. Other examples where resolutions occurred early for the exchange of information. 2 cases with the same attorney, a very prominent plaintiff's attorney. If I mentioned his name, you all would agree. He called me with a case that a client in his office or had been in his office, potential claim. So we triggered our process and exchanged all kinds of information. And we were able to resolve a case involving the death of a young man. Again, no more than a year after the event. It was a great process for both of us. We knew each other a long time, but we haven't really worked in this environment. So it was great. No more than 2 years later, he calls me again. And another case, death of a young woman. Same thing, do our investigation, find out if it was reasonable. I call him up, we start talking, exchange information. He doesn't pursue the claim. What's wrong with that? A system that results in things like that. Good for his client in both instances and good for my client. So confer early and in good faith to discuss the possibility of a resolution. I don't think that's unique to our world. I don't think that's unique to medical malpractice. It should be transferable into virtually every area of litigation. Okay. I don't know, Amy, do you have any examples you want to offer on this one?
I think we can move ahead on this one. Thanks.
Okay. We do not disparage or attack people involved in the justice system or employ gratuitously hostile or demeaning words in our written and oral legal pleadings. Amy touched on this. We don't view our patients as bad people. We don't view their lawyers as bad people. We don't get into behavior like that. What I can confidently tell you is it can be counterproductive. Or counterproductive, excuse me. If you start out and engage in that behavior with us. It can, and we try not to allow it, temper the enthusiasm with which we want to engage people. Amy and I routinely remind each other when we're confronted with stuff like this, don't stoop to their level. We're going to stay the course. We're going to honor our principles, but it's hard. And when we're confronted with stuff like that, it's usually not productive. And this is, Amy, you want to address this and some of the encounters?
Sure. This can come up from time to time. As mentioned, we offer patients and families and their attorneys meetings with our providers. This is incredibly important to our patients with questions. When an attorney comes in less than cooperative with less than civil or professional mindset, it impedes our entire process. We try to set expectations at the front end, but on occasion, we will have an attorney who's not really interested in benefiting from this process. And we will not put our providers in a room to be abused. That's just not something we can do. Again, this is a voluntary process. The moment that happens and word gets around that, oh, don't agree to go along and do it, this ends. So we have to be very mindful of that effect. In the end, when attorneys or patients are not interested in participating in this, quite frankly, they're the ones who lose the most because the patient's questions remain unanswered and the attorney doesn't have advance notice of what our position is. So even tactically, why not benefit from that roadmap? Why not hear what we're thinking now? You lose an opportunity, even if you're hell-bent on going forward with that lawsuit. Why not have these discussions? So we had one instance where we offered such a meeting to parents who lost their child. The parents were keen on it, but shortly thereafter, they decided to get representation, and we heard from the attorney, and we renewed the offer to have that meeting just with the attorney participating as well. The attorney put the stops on any meeting. They weren't going to do it. It didn't make sense to me, again, but we can't force them to talk to us. It's inexplicable why they wouldn't want to hear what we had to say, but we can't force it. A year and a half later, those parents came back to us to let us know that that attorney had decided not to pursue the case, and they were seeking the meeting that we initially offered. We absolutely went through with the meeting, answered many of the questions that they had been sitting on, and even if they didn't necessarily agree with everything we had to say, or they perceived things a little differently, they felt heard. They had their questions answered, and at least they had an understanding of why we were seeing things the way we were. But that mindset of the attorney that they chose to seek disrupted their grieving process by 2 years when they could have maybe started that healing a little better. Another example, we had a case involving a patient that had a spinal procedure resulting in significant nerve injury. We have a wonderful neuroradiologist who was very familiar with what happened, and he put together a presentation, and he was trying to describe exactly what happened during the procedure, and he presented the information in an objective, honest, and informative way. Right out of the chute, the patient's attorney was combative, not listening, just interfering, and that fueled the patient who felt that he was harmed, and the whole thing just was not productive. We had to end the meeting. During those pre-suit exchanges, we learned who the supposed experts were for this plaintiff's counsel, and we told him they're not qualified. Under the statutes, you have to be board certified in the same specialty. I don't know what he was thinking, but they weren't qualified, and we told him that. Still, he filed suit with the same unqualified experts. We went through litigation for a lengthy amount of time, and finally the attorney withdrew and the case was voluntarily dismissed. What a waste for everyone involved. And if only they had been willing to listen with an open mind at the front end, at a minimum, to listen to what we were saying about their own experts, that would have benefited both the attorney and his client, and us, of course, as well. But that's what happens when we don't have the proper mindset, the professional civility coming into these exercises.
Don't want to belabor this. Got a couple other points to go through, but my observation is this idea of avoiding disparaging and attacking people in gratuitously hostile or demeaning way. It starts with your initial letters, your initial pleadings, or in my world, your notice of intent. In fact, in the presentation I had initially wanted to do, proposed to Todd reaching out to Chad reaching out to plaintiffs' attorneys doing mid-mal work, I want to say, don't send notices of intent with 40 people in them. Don't send notices of intent with really inflammatory language. You either know or you darn well should know when you're spitting on an NOI who's really involved in the care. Now, I get it. You don't want to avoid people or miss people that should be included, but you also have to do your homework. You owe it to the system. All these nurses, all these health officers, they're getting a notice of intent. They didn't see the patient or they saw him afterwards, blah, blah, blah. They're unraveling when they get the thing. So these are real people. They're your neighbors, your friends, your family, just like all of those people. They take this very seriously. So don't do that in the initial pleadings. Don't do it in your complaints. What's the point? So that's my personal plea. Plaintiffs, attorneys, just take your time and really think through what you put in a notice of intent or a letter, whatever it is. Avoiding incivility starts with your initial contact with whomever you're going to pursue a claim or respond to a claim. Okay, let's speed things up. Accurately represent and characterize matters in our written and oral communications. Again, going back to notices of intent, and this is counterproductive in our process. It's counterproductive to getting something done in a professional, civilized, civil way. I get notice, or we get notices of intent that are 50, 60 pages long. Recently got one in, very bizarre, which included 50, 60 pages of ranting, and the pictures pulled off the internet of each provider involved. I don't understand that, but it certainly sets the people back on their heels. But more importantly, it was just nonsense. It was an obstetrical case. Got together with my outside counsel. We sat down, started going through things, and I kid you not, we thought we were looking at monitor strips from a different patient. Didn't come close to matching what was in the notice of intent, 50, 60 pages. So what do? We reach out, we want to initiate our process. We want to exchange information, do all the things the Supreme Court and the State Bar wants us all to do. The response was dismissive, hostile, filled with words I won't say today, until it came to a halt. We don't have a lawsuit. Doesn't have anywhere near the right facts set forth in his lawsuit. He's got experts who apparently can't read monitor strips. I don't know what's going to come of that case. All I do know is we're going to litigate it in a very expensive way for a long time. If he had accurately represented the nature of his case in the initial documentation, I would have had an opportunity to look at what's really at issue and move along and try and do the right thing, whatever that may have been. We act in good faith to advance only those positions in our legal arguments that are reasonable and just under the circumstances. That applies more to outside counsel than it does to the two of us, because we're not writing and filing briefs and arguing things in court by and large. But I do know I don't ask or condone, I don't allow, frankly, outside counsel to file motions that are sort of made up. They wouldn't be on my list of attorneys if they did so anyway. So we don't do that. Amy, is this
I will say on this point, We won't hang our hat on a technical legal defense in the face of inappropriate, unreasonable care. If those of you might remember the APSI and sometimes even statute of limitations defenses, we won't hang our hat on those. We will advance those arguments if the care was appropriate or if it helps get the other side reasonable on damages. You know, we have those, but we try to really do the appropriate thing there as well. I think where this gets very frustrating is we see a lot of these life care plans that are just so inflammatory and so exaggerated, and it's useless, quite frankly. If we've seen them as much as $500 million for life care. What are we going to do with that? That's not helpful. And on the flip side, it's equally not appropriate for us to err on the other side, you know, so we really find it important to really keep it reasonable and what's just under the circumstances there.
Okay. We accord professional courtesy wherever reasonably possible to other members of our profession. Again, mostly applies to outside counsel. But I do have a couple of observations that just rub me wrong. One's from my private practice years ago. Bad case. Wasn't going to take it through trial. But all the usual stuff has to be sorted out. Lawsuits filed. I was really bad at scheduling vacations. And it also seemed every August and December I had trials. So I had a trial open up, or trial get adjourned for an August date. At the time, I have 3 young kids. Hallelujah, we can take a vacation. I'd book it, everything at the last minute. A week before I was scheduled to leave, in that very bad case, which by the way is up for trial in November, we're in August. I get motions in limine, 12 motions in limine. Oh, son of a gun. This is before emails and all that good stuff. So I reach up, I call the plaintiff's attorney and describe the circumstances. Can you put this over a week or two? No. What? Their motions in limine. Trial's up in November. We don't have a court deadline that says they have to be heard by August. No. Long story short, I went up north, took 2 briefcases, spent the first 4 days preparing responses, didn't have emails, had to write them out, and then overnight them to my assistant so she could type them up. The night before the vacation or the motion, I packed up, had a 6-year-old son who was despondent over me leaving, so I took him with me. Drove back to Ann Arbor, got up the next morning, argued the motions, drove back that night. The first 4 or 5 days of my precious vacation were gone. And why? And then equally egregious, if not more so, one of the lawyers I use, and many of you will know this and who I'm talking about, has a son who has a just significant, horrible health situation. We had a trial up a few months ago. We're peripheral players on this case. It happens that his son needs urgent surgery and has to be admitted at the point in time this case is going to be tried. He calls up the plaintiff's attorney, explains the situation. Can you adjourn the trial? Or stip to adjourn the trial? No. He had to file a motion. I want to know in what world that is sane. What world do we want to promote that behavior on behalf of our brethren? We don't. So don't. Okay. I'm going to sort of wrap things up there, but I want to end on this note. We live in Eden. We have all kinds of resources, but all the good things we try and do are born of principles, and I'm convinced can transfer over to your practice. You just have to try. You just have to try. And maybe I'm an old guy now with, you know, my feet up on a desk and cigar in my mouth and a glass of scotch, and I'm thinking back about the good old days. But no, you can do it, but you have to try. Is our process perfect? No. Am I perfect? No. I get it wrong. I am probably viewed by some of the people I'm interacting with as, oh, not so reasonable. not so courteous, but I try. Whatever judgment we make, whatever judgment I make is in good faith. It's after listening to everybody, saying what I need to be said. Every judgment is in good faith. I could do it as an auto neg defense lawyer, a premises defense lawyer, a plaintiff's attorney. You can do it then in that environment, or our environment, you can do it in that environment. Not going to be as easy, but it can be done, and more importantly, needs to be done. Okay, I'm going to leave it on that note, Chad, unless you want to weigh in.
Well, I do want to, I have some observations. First of all, thank you both so much for explaining the process and the principled approach that you're taking at Michigan Medicine and the University of Michigan, and for sharing some of your own personal experiences in how civility and professionalism and the kind approach isn't detrimental to success, it's integral to success. And you've given us some real life examples of that, as well as some of the detrimental effects of unprofessional or incivil approaches. This program is part of the Civility Matters initiative that was started through the mediator that Amy referenced. I think it was Bob Riley, our past chair, along with Deb Freed, who at the time was the president of the American Board of Trial Advocates Michigan chapter. And you both have referenced the Administrative Order 2023 from the Michigan Supreme Court. I've put in a link to that in our chat if anyone wants a copy of that. And as well, with our survey, we'll send out a PDF copy for all the participants that were here today, along with any materials. Amy mentioned an important concept, and that was repairing relationships. And I think too often what we see is, instead of attorneys looking to help their clients repair their trust and relationship with a healthcare system, with the world maybe, they sometimes uncivil or unprofessional conduct comes from attorneys throwing fuel on the fire, for as Dale mentioned, several occasions where they, for tactical or mercenary reasons, and that should never happen. And it's something that we all have to take a look at to make sure that we're not doing, and also to take a look at our own practices and make sure that we're living up to that we're walking the walk, not just talking the talk, but we're living up to our own ideals. We stumble, we fall. None of us are perfect, but we're all trying to make a difference. And we've talked a lot about pre-suit and trying to work things out and resolve things amicably early, but we should also be looking throughout the course of our case, looking at our own cases and the other side critically, and not being afraid to approach each other early on or throughout the course of litigation. Hey, our clients have each been through a lot. Let's see if we can reach some conciliatory reconciliation without the need for facilitation or without the need for mediation or case evaluation or some imposed process. Dale mentioned that it seems that kitchen table negotiation, the art of just reaching out to one another, has fallen off the table. We have skilled mediators, but we should certainly be looking to reestablish that relationship with one another. Amy, what final words do you have for us?
I couldn't have put it better than what you just did, Chad. Honestly, that really sums it up. And as we were going through this, I was thinking this is a lot focused on pre-suit, but you're right. A lot of these principles can be carried over into how we behave in litigation as well. There's no lost opportunity. Every step of the way is an opportunity to employ these principles. So I appreciate you making that observation.
Well, this webinar is going to be available to our members and to others through the State Bar of Michigan website. It'll be posted to the section's private YouTube channel. And as well, I know it's going to be featured in at least one law school class this year and hopefully going forward, and it'll be part of our index. of the Civility Matters Initiative. And I can't thank you, Amy and Dale, enough. And also thank you again to our sponsors and to Owen and Tara and Madeline at Shared Resources, our administrative arm at the State Bar of Michigan Negligence Law Section. I'm going to check the chat box and see if there's any comments or questions in the Q&A.
Any tomato memes?
Nope. I just have one from Randy Yipe that says, Dale is looking as handsome as ever. Okay.
Hey, Randy, what about me? No, you can't say that.
Well, I was looking at the Zoom settings and I thought, boy, the Zoom settings must really be highlighting the gray in my beard and Dale's hair today. Well, again, thank you both so much for being here and sharing your wisdom and your perspective as a unique perspective that really brings in the best principles that we endorse and that we ask our members to likewise endorse. With that, we'll be closing the program. There were no questions, but if anyone has any comments or questions or feedback, number one, Madeline and Shared Resource will be sending out a survey. Please do share with us your thoughts about this presentation and also about what other presentations you want to see in the future, because part of our mission is providing high quality continuing legal education and ethics presentations to the bench and bar. As well, if you have other questions, Dale and Amy have graciously offered to field those. You're welcome to send an email and we'll get it to them, or you can email them directly if that's okay. And they'll be happy to answer those. And the presentation that Dale and Amy so thoughtfully put together, featuring the Supreme Court's 2023 orders and the principles used by the Supreme Court and the university, will be made available on our website as well. That'll be a PDF that'll be part of our materials of the website. And with that, folks, thank you so much. And we'll just stop the presentation now.
Thanks, everyone.
Thank you.
Bye.